Welcome to the Top Texas Lawyers Podcast. This podcast is brought to you by the law firm of Abercrombie and Sanchez, PLLC. You can find us on the internet at astxlegal.com or by calling 1-888-981-7509. Your hosts are Bryan Abercrombie and Samuel Sanchez. Bryan has been practicing law for 18 years and is board certified by the Texas Board of Legal Specialization in the area of family law. Sam has been practicing for 13 years, is licensed in both Texas and Florida, and is a certified mediator. This podcast is for informational purposes only, and all views are the opinion of the hosts. It is not designed to provide legal advice for your particular legal matter, and it should not replace the advice of competent counsel. Welcome, and we hope you enjoy the Top Texas Lawyers Podcast. Good day to you, and welcome to the Top Texas Lawyers Podcast. I'm your host, Bryan Abercrombie, and with me, as always, is my co-host, Samuel Sanchez. How you doing, buddy?
Hey, doing pretty well.
All right, so let's talk divorces in the news. First up, we always give a little bit of an entertaining tidbit. We're going to talk today a little bit about separate and community property, and then some changes in the law in Texas that just occurred on September 1st. But let's first talk about divorces in the news. What I have, and you may have something else that's titillating and exciting, but I have Larry King, 85 years old, files for divorce from his seventh wife after 22 years of marriage. Apparently, there's going to be a battle over money and infidelity. So, Larry, that's seven. That's a lot more than most of us.
Larry is a powerhouse. Let's just call a spade. Larry is a powerhouse. That is incredible. On that, since we're talking about a little bit of infidelity, I didn't know if you know, and I'm sure listeners might be interested to know as well, Bryan. As of September 1st, there's a new law in the state of Texas that says that it is illegal for you to send, or it's a crime for you to send an unsolicited nude pic on your phone.
Well, that gets rid of some people's social lives, I guess, right?
to say the very least. And I mean, a big part of that is, obviously, most people talk about Texas and they say, well, we're no fault, but we do have fault divorce, as you and I both know, and that can be a big part of it. And so if, especially in a digital age, you and I both know with all the apps that are out there, I mean, a big part of this law that I think is a little bit concerning, and hopefully it doesn't apply to Larry and he wasn't in Texas, but if he was found to be sending these unwanted nude photos, it's a Class C misdemeanor now with a maximum fine of $500. So, and it's pretty wide open right now as far as what.
And that's per picture, right?
That's not per picture. Yeah.
So be careful out there before you send those pictures of your private parts to people who don't want them.
Yeah. I guess ask for a release or say, please send me a message that says, please, I want those.
So what we wanted to talk about a little bit today, and this is where that can kind of come into play, is the issue of divorce and property division, which can be big. And then you and I both know in Texas, property division can be divided. It can be. We're in a community property state, but property division can be skewed a little bit based on fault in the breakup of the marriage, and of course, one of those fault grounds being infidelity. So let's chat about that a little bit if you want.
Yeah, absolutely. I'd love to take that up, Bryan, because I think that a lot of people, most of the time, like we said before, really feel like, hey, in Texas, we want to get divorced. What are reasons that we need? Well, it can be as simple as she burnt my toast this morning, or like, the eggs weren't good, or she made a terrible dinner, or she didn't make up the bed. No fault means you can be divorced for any reason under the sun. You really don't even have to state one other than insupportability. But fault is different. Fault, one, raises the preponderance of evidence that's going to be required in the case, right? So you and I both know what that means is whoever's going to assert or allege that somebody is at fault in the breakup of that marriage is going to have the burden or the responsibility of proving it. Some of these things, are simple. As an example, and we'll talk about later in future podcasts, violence, family violence. Well, that's usually something that's not going to be very complicated to actually prove. Maybe there's police reports, maybe there's medical records, photographs, but still all that evidence has to come in to substantiate those claims. Others that are out there, fraud, people hear that and they say, well, what does that mean, right? Fraud on the community. Was a husband and a wife, you are considered fiduciaries. Fiduciaries meaning that you owe each other a duty to be fair and just in the way you handle finances. Well, you and I both know, Bryan, that, you know, a large reason for people to get divorced in any state, in any jurisdiction, is money, and how people are handling or not handling that money, and wher they're disclosing those transactions, right?
Let's talk a little bit about examples of, say, fraud and fraud on the part of one spouse against another. Because I think people are like, well, wait a minute, well, I'm married, so she's going to know what I'm doing, or he's going to know what I'm doing. What are some kind of examples of a fraud in a marital relationship?
Sure. I mean, simple ones are, let's talk about like just cash, right? Cash is king still in every state. But let's say you take out some cash and you want to go gamble at WinStar in Oklahoma, or go to Vegas and take a trip with the boys and spend some money. You're entitled to spend community property. If you earned it, it's during the marriage, both of you own it 100%, you're entitled to spend it. That's not really the issue that we're talking about. It's where you're doing it behind the back, right? So as an example, you get a bonus. It's $20,000 bonus. You're excited. You're like, this is going to be great for me and Sam to spend some money in Las Vegas. And your wife, who I know very well and is beautiful and fantastic, might not appreciate that very much. And so she may have a different purpose or intention for that money. So instead of you disclosing that, hey, I got a $20,000 bonus from work, you decide not to tell her. You're going to keep it a secret. You're going to maybe alter some documents, or shred some documents so that she doesn't know that money came into being. And then, hey, guess what? You and I go to Vegas and we have a great time. Well, that is in essence fraud, because what you've done is you've taken money that, yes, you were entitled to spend, but you mismanaged it in a way to one, eliminate disclosure to your partner, which you should always do, and then two, diminish that value or dissipated those funds by exhausting them in whatever way you decided to do it. It could be a bad business investment, it could be gambling, it could be on a paramour, or a girlfriend or boyfriend. There's 100 different ways that you could do that a court can look at you and say, that wasn't the right way to do things.
So if, let's say I'm caught with my 20 grand, I dropped at the blackjack table or whatever, and I'm, and the court's going to lay the hammer on me for mismanaging or fraud. What does that normally look like? Listen, the 20 grand's gone. She's not going to get it back. What does that look like?
Well, it depends on the size of the estate. So let's say, as an example, the court can look at it and say, well, we're going to put that $20,000 on your side of the ledger. So as we go to divide up assets, tear the sheets, we go and we set financial, assets values, and we're going to distribute those between both parties. Well, if there's $20,000 that's spent no longer exists, and the court says, hey, you mismanagement, or you perpetrated fraud on the community in the way you handled this transaction, they can assign that value to you. You can say, well, I had a terrible time in Vegas. I lost $20,000. Well, you're going to show a $20,000 debit on your side of the division, but no value there. Your wife, on the other hand, would take $20,000 from an asset that does exist, if it exists in the estate, to counterbalance what you did. In addition to that, though, it can have long, far-reaching effects as well. Because let's say that you were in a long-term marriage, and a court looks at that and says, well, if fault can be proven, does that open the door for anything else? Well, potentially. I mean, it could open the door for spousal maintenance, Texas's version of alimony. Somebody could look at that, and the court could say, well, based on your actions, does that afford her the opportunity to potentially get some payments? Maybe.
And you're talking about the marital misconduct portion of the alimony provision here in Texas.
Correct. So it can be far-reaching.
Let's talk about how far these courts. I mean, Texas, as you know, is a community property state. So most of these community property states, we come from originally Spanish law. So most of the states in the Southwest are going to be community property states, which means that generally that most property divisions all start out with the property being split at 50-50. But there are some variances to that, correct?
Correct. Absolutely. So let's say they say, okay, you've been guilty or found that you were intentionally perpetrating fraud. Well, now a 50-50 division might not be applicable. So a court can not only look at that property division percentage, because really in Texas, the division is a just and right division. Everybody says 50-50 because we say community property, but that's not really the law. The law in Texas is a just and right division. That could be 49-51. That could be 47-53. Who knows? It's up to the court. But it's typically 50-50. Unless you're at fault, then the court can say, hey, bad player, bad person, bad actor, we're going to punish you. We're going to give a percentage based on your behavior to the other side in compensation for your behavior because you're the reason that this relationship is ending. That could be 5%. That could be 10%. So it could be a 60-40 split. If it's egregious, it could be 70-30. I mean, it just depends on the facts that are put forward. It's a very fact-intensive inquiry that a court's going to consider.
Now, I've been practicing law for a number of years. The biggest property disparity that I ever saw was around an 80-20 split of a really pretty small estate, and that was based on, I think the judge saw a 20-year history of family violence and really put the screws to this guy and divided the property up 80-20. That's the most egregious I've ever seen. I mean, most of the time, I think we're seeing 55-45 being a good day, 53-47, and maybe 60-40 is a home run. It really just depends on, it's very fact intensive, very fact intensive inquiry. And, you can sway that a little bit, but normally you're seeing things that are in the 50 to 60 range, 10% delta, correct?
Yeah, I would say that that's a fair amount that you're going to see for some pretty crazy behavior. I mean, you and I both have gone through some pretty big wars, some pretty scary cases. And I would tell you, I've seen similar things, 80-20s, extreme. 70-30 can happen, especially the way people just tend to sometimes lose their mind through this process. I do crazy things, they're destroying airplanes or they're breaking into houses or they're, engaging in all kinds of silliness and antics that create the opportunity for a court to get very creative. What you don't want to do is have a court be creative because you want them to kind of really just apply the law simplistically, if at all possible.
Let's talk about you, Sam. Let's say you inherit a 4,000 acre ranch from your dad, and let's say that you're getting a divorce, and that is that ranch up on the chopping block?
Not typically, but I will tell you that you got to be careful, right? So inheritance is usually going to be categorized as a person's separate property, depending how it's inherited. So, I'll give you a good example. Let's stretch that ranch example to, post-marriage. Everybody's happy. You're in the honeymoon stage. Your parents want to give you guys some money to get started. And so your parents or my parents decide, hey, we're going to give Sam $20,000 to put down on a house for him and his wife, his young wife. I would tell you that $20,000 gift presumptively is to both parties if they don't specify. Right, but let's say they wrote a nice little card that says, Sam, this is for you because we love you so much as a son. Then it's going to require the person who is going to assert separate property has the burden of proving it, just like in fraud, just like in anything associated with fault or any higher burden. That's a clear and convincing burden in Texas. So to kind of give you an example that kind of will maybe help clarify it a bit. Preponderance of the evidence is really the baseline of what we apply in marital property law in Texas, and the same thing is really in Florida. What that means is, if you had a ream of paper, 500 sheets on one side, 500 sheets on the other side, and you took one piece of paper and you moved it from one 500 ream to the other and made 501 and 499, that is a preponderance of evidence sufficient to be able to award somebody something.
I always like the football example where to score a touchdown, you have to get to the 49, the other team's 49-yard line rather than getting to the ends all the way to the end.
Exactly so. That's great because we're in football season and I love football, so we'll go with that. But I will tell you, Bryan, so like in clear and convincing, it's completely different. It's more like going 80 yards. So instead of having to just cross the 50, now you're having to go all the way to pretty much the 20-yard line. It's not necessarily a full-on, beyond a reasonable doubt, which is you cross the goal line for the most part or get pretty doggone close to it. It's the threshold between those two that this burden is going to apply to whoever is going to assert that. So in this example that we talk about, this gift for the house, that $20,000 gift, you're going to need something substantial to be able to say, because in Texas, it's a donor's intent, right? A donative intent. Whoever donated that money is really going to be the person. Well, if they're around, great. They can just sit up there and say, no, it was a gift to my son. But if they're not around, right, and you've got that money and it's 17 years later and you want to try to assert separate property, you could have some problems. So you really need to kind of make sure as you're having these kinds of things occur, whether it's an inheritance from a family member who's alive inter vivos, or, it's passing from a will inheritance or, probate estate or something like that, you're going to want to really maintain that documentation to help secure that portion of the estate going forward.
Let's talk a little bit about something that's maybe a little bit closer to home for people. I mean, we got a lot of blended families nowadays. You got, parents getting remarried. They've got kids, or they've got, retirements from other jobs, and they're bringing them into the marriage. Let's say you have a 401k from your prior job, and you get married. Let's talk a little bit about what happens to that 401k. How's that 401k classified?
Sure, it's really at the point that, let's say, you've kept it from a previous relationship, or before you owned it before you entered into this second relationship. It's going to be commingled, because what ends up happening is, if you're still employed from that company during the course of the marriage, the new marriage, that money that you contribute is money earned during the marriage, is community property. The overwhelming presumption in Texas is that anything that comes into existence from the date of marriage to the date of divorce, and just as an FYI to everybody, Texas does not have legal separation. There's no such thing. So you're either married or you're not. And in this instance, you would be married. So any money earned is community, meaning that you both own it 100%. But the money that you brought into the relationship is separate. And if it's in the same account, you've commingled it. So what do you need to do to be able to assert this claim properly is, one, maintain records, right? Get a statement of the balance of the RRA or the 401k account as it existed the month before marriage, the week before marriage.
The other thing to recognize is, even though you have that separate pot of money that you're bringing into the marriage, the interest that's earned off of that pot of money is community property. Now, if you own shares of stock, and the shares of stock, say you have IBM stock and it goes from $50 to $80 a share, that'd be great. That remains your separate property. But things like interest earned off of a 401k or an IRA typically is going to be community property, because income off of separate property becomes community property. So just so people are clear, I mean, in Texas, everything is presumed to be community property unless you can prove otherwise. And the main things that are not community property or separate property, and typically that's going to be stuff that you brought into the marriage, stuff that you owned before the marriage, stuff that you inherited, or stuff that's two spouses agree in writing is going to be separate property, which doesn't come up that often, but does come up.
Yeah, no, absolutely true, absolutely true. And the big piece of it that I find is not only that, but distributions, Bryan, is what a lot of people get caught up in this. Because they'll say, hey, you know what? I had a 401k account from a business or a company that I worked for, and I left that before we got married, started a new job during the marriage, but I still have that account. Shouldn't it be 100% mine? Well, just like you said, interest is going to be, because that's considered income, community. So are just distributions that are reinvested. So let's say it was restricted stock units, or it's, stock options, whatever it may be, that are redeemed and then invested back in. Just because you owned it outright, once it turns into income, it can cause a commingling situation that will require tracing. And tracing is, for those of you who are kind of new to this process, tracing is just where we're going to get a financial expert, a forensic accountant, who's going to go out there and they're going to do a lot of homework off of all the documentation that you can produce, meaning all the statements, bank accounts, registers, everything that we might need to be able to show where money existed and where it transmutated either from separate to community or commingled to separate those balances. And those reports are worth their weight in platinum, because that is how you're going to preserve that separate property interest that may exist if and when you need it.
And if these cases go to trial, and there's a trial over property divisions, they can get pretty expensive, can't they?
Bryan, obviously, I try to tell clients that going to court and fighting, it's like playing the sport of polo, and I'm sure being as close as we are, all your friends play polo except for me. I will tell you that that's not the case in relation to my side. Exactly, right? Well, it's called the sport of kings. It's called the sport of kings because it's super expensive to play that game. And I would tell you that it's super expensive to go and fight with people about things in court, which is why it's so important, this documentation that we're referencing, this burden that's going to be on you as things happen, as inheritances happen, as awards or gifts happen. You really want to maintain documentation, because that burden is going to be on you going forward.
And if you're dealing with, a high net worth divorce, I mean, and these are parties that have more than $1 million in assets. I mean, a 10%, or even 5% property division can be pretty substantial. You're talking about, potentially, $50,000, $100,000 difference in a property division for 5 or 10%, depending.
Oh, absolutely. And not only that, Brian, but you know what, I would tell people, like, you know, if you think back as you reflect on your life, the things that matter most to you, sometimes it's these high net worth items, but sometimes it can be the simple things, the things that you were given or gifted or inherited from a grandfather or a father. It could be, you know, a firearm that's been in your family for 20 years, or a piece of artwork that your mother or your grandmother or aunt, you know, painted for you. And these are things that become very complicated in relation to preserving, but they would be considered and potentially be considered separate property. But you know, again, that burden falls on you. So it can get complicated, but it can be, you know, people go to fight over a lot of things, expensive things and less expensive things too.
Well, let's talk about the couch and the pillowcases and the beds. How are those typically divided up?
Yeah, I would tell you that anything that came into existence during the marriage is going to be presumed community. So that means if you bought a sofa, washing machine, you know, television set, computer, and you bought it with community money, it's community property. Now, let's say, though, that you were purchasing things from your inheritance account. You have an account. It's been separate. You've kept it separate the entire time. You pull money out of the account to go in and buy you a Mac laptop or that brand new 85-inch super high-def television that you always wanted. Well, guess what? The character of property in Texas is created at the inception of title. So if you had that money and it's separate and you can trace it, again, you can prove that it came from these separate assets. That television is now your separate property. It's not available for division through the community division of a divorce, okay? But if you don't do that and you buy it just generally, it's going to be presumed community. So let's talk about how people, you know, because people get sideways on that kind of stuff. They say, you know, I bought this really nice sofa. My God, when I bought it 5 years ago, it was $10,000. It was top grade Italian Corinthian leather. We all know Corinthian leather. And so, you know, I try to tell clients, yeah, but you sat, you know, your booty on that sofa, I don't know, a few thousand times over 5 years. And so it's not worth $10,000 anymore. So even if it was separate property at that time, it's going to be very difficult for you to assert that it's $10,000 worth of separate property. It just means that you owned it separate and outright. So
let's talk about how you value that kind of stuff. So let's say, how do we value the rug or the kitchen or the nightstand or the kitchen table? I mean, how is that valued? It's not what we pay. We went down to Gallery Furniture, and which is big down here in Houston, but it's not what you paid for at a gallery, right?
No, absolutely not. Unfortunately, I think people would love it if it was that way. But the way a court looks at it is, and what can really frustrate parties, is they really look at garage sale value. You know, when you look at an asset and they say, well, if you're going to have a garage sale, and we've all gone through those, you put stuff out in the front lawn and people come in and you may think it's worth $1. But by gosh, somebody's going to come up and say, I'll give you a dime. And you're like, but I want $1. And it ends up selling for 20 cents. Well, guess what it was worth? It was worth 20 cents. And that's the way a court really looks at personal property. You know, that's sofas and sheets and curtains and washing machines and all those kinds of things that we spend a lot of money to acquire and accumulate. But when it comes time to divide it, they really diminish in value tremendously, especially if you have to go to court and fight about them.
I mean, oftentimes the lawyers, you know, kind of kid about, you know, we know things, family heirlooms are important, and there's a lot of sentimental value on things, but lawyers often joke about how it costs more for two lawyers to argue about the couch than what the couch is actually worth, even if it's the $10,000 Corinthian leather couch.
That's absolutely true. I try to tell clients, if you're going to get hung up on something, don't get hung up on stuff, right? Because stuff is things that you can replace. Now, if it's irreplaceable, okay, maybe it's worth taking a look at. But honestly, most of the time, anything that we buy can be replicated by something newer, faster, cleaner, prettier, you know, just like me and you, Brian. We're always replaceable.
That is true. And, you know, and what I always tell clients is it may not be the stuff you picked out. Maybe the stuff in your house is a compromise. You know, maybe you don't want to compromise anymore. It's time for your fresh start. It's time for you to get a new couch, time for you to get a new table, whatever. But I would tell you that, you know, things that have a title to it. Maybe there's a registered firearm, or maybe there's a painting with some kind of a value, an appraisal to it. Those are the kinds of things that are worth looking at and potentially worth fighting for, because they do have value outside of garage sale value.
Yeah, absolutely. And the bigger piece of it that we're finding now more and more is, we're in an entrepreneurial state, right? And so business interests are things that tend a lot of times to complicate matters, especially if, like, as an example, you've inherited a business interest from your father. So you're working in the family business, but, you have stock options that are issued or percentages of ownership that are awarded. How do those get dealt with in court? Because that's when people really kind of look at something and say, hey, this was built by my family. It's been in my family for generations. Ranching, value, oil interests. I mean, all these kinds of things, can get extremely difficult to divide up and ascertain who owns them as you go through this process.
So let's talk about that for a second, because if you think about it, I've got this family business that's been in my family for 100 years, whatever it is, and I don't want my spouse to get any part of it because she's not a member of my side of the family, and it needs to stay on my side of the family. So what are the vehicles that I can use to kind of to go into the marriage? I want to be honest with her and say, hey, we're keeping this on my side of the family. What are the vehicles that I can use to try to make that happen, given I live in this presumption of community property state?
Sure. I mean, the big one is obviously the prenuptial agreement. Prenup, and then obviously post-marriage, what we would either call a post-nuptial or a partition agreement. The prenuptials are so important because, honestly, here's what I try to tell people. I mean, you're gonna fall in love, whether this is your first time, your second time, your eighth time, as Larry came up with. However many times you're gonna fall in love and want to get married with somebody, those prenuptial agreements become very important because it forces everybody to be absolutely 100% transparent with one another about the finances. This is absolutely everything that I own, everything that I owe, and we're going to be very clear about what is going to happen once we get married. And it gives people the opportunity, Bryan, these prenuptial agreements, to have conversations that they should be having anyways, which says, what is mine? What is going to be ours? How do we want to handle our relationship going forward? Because obviously you and I both know marriage was created just for a transfer of wealth in the old days, right? Hundreds and hundreds of years ago, that's the way they would transfer wealth between families, generationally. Well, marriage is kind of taken on a new role. It's more of this kind, there's a huge sentimentality portion of it, but it's still a fiscal, financial transaction between parties when you get married. And so at that point, it becomes really a very powerful tool for everybody to be just, open and honest with one another, and then really start on a good foot financially as far as what exists and what doesn't, and what we're going to share and what we're not going to share. So that would be number one. Number two is the post-nuptial or partition agreement. I like to try to tell people that these two things go hand in hand like shoelaces, right? So it's very difficult to tie one shoelace, but when you have two shoelaces tied into a bow, it makes a nice tight running shoe for you to be able to be off and running in the races. Post-nuptial is post-marriage. We usually try to recommend that people don't do it for 6 months after marriage. It usually should have a counterpart of a prenuptial, but doesn't have to. It can stand on its own, meaning that you could go in and say, hey, we didn't do one before we got married, but why don't we go ahead and think about doing one now? Well, great. You can still do that. It's still available to you at any point in time during the marriage. So those are really the big vehicles that we'll use to kind of try to create separate property if there isn't any, or identify what's separate and what's community as you go forward.
So I had this come up in a case recently. What has to be spelled out in a partition agreement to make it clear that you are dividing community property and making it separate property?
Well, I mean, I wish I could say it's a short list, but it's actually pretty much everything that's going to be, it has to list all the assets, all the debts with specificity, meaning that you're going to say exactly what something is, account numbers, balances, as of a date certain. It has to be sworn to, meaning that you're going to execute this in the presence of a notary and witnesses typically. So that way there'll be people who can say there was no duress or, unforced, undue influence in executing something. And on top of that, we usually tell both sides to get legal representation. Before you enter into any type of contract in the state of Texas, especially one this important, you're going to want to have the advice of competent counsel.
And it has to be absolutely clear on the document that you are partitioning this property out, community property anymore.
Absolutely. Yeah. I mean, there's the cool part about a prenuptial and postnuptial agreement as you know, Bryan, is obviously you can be very creative. There's a lot of things that we can do to address and allay parties' concerns, because I would love to tell you that, everybody gets married when they're 21 and both parties have nothing. But that's just not always the case. Nowadays, people are waiting longer to get married. They're establishing themselves in careers and investments before they get married. And so you bring into, a lot of times into a relationship, substantial assets. And even if you don't, you want to plan and forecast, not for the demise of the relationship, but potentially just so that there's clarity. So that if, for whatever reason, something were to happen in that relationship, both parties can part ways, if at all possible, friends. Right? It eliminates the fight, which is where obviously we make a lot of our income, is people fighting about stuff that maybe they shouldn't, or maybe that they just can't seem to agree on. But a prenuptial ends all of that. So does a partition agreement.
And it would also protect, let's say your kids don't get along with the new stepmom, or the kids don't get along with the new stepdad. It would also protect at least some of your property. Let's say you were to die first, and it also protects from a standpoint of creating your separate property so that your kids potentially can inherit something that's yours, as opposed to something out of the community estate, which may all go to the new spouse.
Sure. And that's something that I would always encourage clients, and you and I both talk to clients about your estate planning, the effect of, what can happen if a party dies during the marital relationship with assets as they exist. And so these are really kind of like fingers on a hand. Family law is a part of it. Probate law is a part of it. Estate planning is a part of it. You're going to want to incorporate somebody who has some knowledge and expertise in all of these areas to help you really put together a very well thought out and strategic plan on how to address property, both community and separate, throughout the course of that relationship, all the way to.
So back to the Larry King example. He's on his 7th wife, 8th marriage. You're talking about, there's some children out of all of those different marriages. So if something were to happen to Larry, who's 85 years old and has I don't think it's no secret that he's had some heart problems. It's something that he could potentially protect his children, from a various number of ex-wives or whatever that may be. The rumor here is that some of the kids don't really like the way the 7th wife has been acting, with the baseball coach and the public speaking gurus and all this kind of stuff. So maybe this is something that, he wants to protect his assets for his children.
Yeah, absolutely. And I think anyone who, whether you're the wage earner, the money maker, the wealthier party, both sides really should want to take a look at, the situation financially and make some very strategic decisions as you enter into the relationship like that.
Okay, well, I think that's going to wrap us up for today. I really appreciate you joining us. And if you want to have a consult with either me or Sam, we are available. And you can call the 800 number that will be listed here at the end of the show. And if you have any questions we can help you out with, I really appreciate you joining us, Sam, telling us all about separate and community property. And have a great one.
All right. Talk to you soon.
Take care. Thank you for listening, and we hope you enjoyed the Top Texas Lawyers podcast. If you would like a consultation with either Bryan or Sam, please call 1-888-981-7509 or visit us on the web at astxlegal.com. Once again, that's astxlegal.com. Thank you very much.